designed for Rotary, what's the month where we talk,
It was like February, I think.
Vocational.
it was vocational month, so because of the winter and everything else, we're just now getting around to it, so here we go. Today's topic, and oh, by the way, for those of you who've been around when I was president, you know I carry this.
Do the do.
Today's topic is called Relationship Planning, a Suggestion for a Broader Approach. Some disclaimers, of course. First, this is not to constitute legal advice. Its purpose is to provide general information only and considerations to discuss with the counsel of your choice based upon the specific facts of your situation. I'm licensed to practice only in the Commonwealth of Virginia. This presentation does not speak to the laws of other jurisdictions. Domestic relations law can vary greatly from state to state.
What about Pinch County?
Luray, like Fairfax and the People's Republic, Arlington County have their own ways of doing that. The views expressed in this presentation are solely my own and don't necessarily reflect the views of my firm. Brief introduction, or pleased to meet you, won't you guess my name? I've been licensed to practice law in Virginia for 20 years as of April. I've been 19 of those years have been spent in Front Royal. Domestic relations law is part of my office's practice as well as my own from time to time. And I mean from time to time. But the reason I picked this as opposed to something else that might put you to sleep is I bring some personal experience to this topic. I've been on both sides of the divorce process. I joke that if I just develop a drinking problem, I'll be the perfect lawyer. But it was this experience and seriousness that inspired this presentation. While some of my observations will apply to any committed long-term adult relationship, I will primarily be discussing marital relations. Why? It's the relationship most recognized by Virginia law with the most developed, well-developed body of law. However, I will have a brief word about non-marital committed relationships at the end. Some hard realities. The decision to marry is probably one of the 2 or 3 most long-reaching decisions you will make in your life. The others, I would say, are whether or not to further your education and whether or not to have children would be the other 2 I would add in there. All marriages end. All marriages will end by one of 2 different means, death or divorce. Either the death of or divorce from a spouse are traumatic emotionally, legally, and financially. The following conviction is the heart of this presentation. Good legal planning for both death and divorce is essential. One of the purposes I hope from this presentation you will leave with is oftentimes people have a stigma attached to things like prenups and marital agreements. I hope to be able to somewhat dispel that notion. One of the foundations for healing emotionally from the loss of a spouse or partner is certainty and predictability in legal and financial affairs. Simply put, chaos and multiple unknowns do not encourage healthy coping. You only move on when you believe there's life at the end of the relationship. My 2 iron laws of divorce. Iron law number 1, the Commonwealth of Virginia will not force a spouse to stay married to you. After all, the Constitution prohibits cruel and unusual punishment. Iron law number 2, in the event of divorce.
May 14th coming fast.
Well, May 15th, my parents have been married 48 years, and every year I tell my mom, there are people who killed people who've been out of jail already. What did you do?
Retirement.
He's retired last year. In the iron law number 2, in the event of divorce, it is always to both spouses' advantage to come to an agreement about issues versus litigating them. Indeed, the vast majority of divorce cases end up resolved by agreement rather than litigation. And that's really true of pretty much everything when it comes to is I would say 85 to 90% of all disputes or criminal charges end up in some form of negotiated resolution. Let's talk about marital agreements. Virginia allows couples to enter into valid and binding agreements regarding distribution of assets and liabilities, as well as spousal support or the waiver of spousal support in the event of a marital dissolution. And they allow those agreements to come at all stages of that marital relationship. You have prior to the marriage, which referred to as the prenup. You can have them during the marriage, which is something that a lot of folks don't realize. And finally, at the end of the marriage, which we like to call the PSA, or Property and Settlement Agreement. One big caveat: children, custody, visitation, and support. The parties' ability to create binding agreements regarding children is more restrictive and never completely final. That's because the Commonwealth of Virginia maintains an interest in children up until they reach their majority, graduate high school. Once the parties enter an agreement at any stage of the marriage, divorce litigation becomes a largely administrative matter. For example, in many jurisdictions, including Warren County, parties with the appropriate agreement can get divorced without enduring a hearing of any sort. As a matter of fact, the Commonwealth has made it even easier by allowing people to get divorced with a combination of agreement and affidavit. In other words, you never have to step foot inside a courthouse unless you absolutely really want to. You don't want to. Okay. Legally, a dissolution of a marriage is always possible because it takes only one spouse to initiate the process. One thing I will tell you, every day you wake up, both of you got to agree to stay married. If one of you wakes up and don't share that opinion, then dissolution is the inevitable consequence. As I've said before, an agreement is your best option. So, with that in mind, when do you think is the best time to negotiate an agreement? One, before you get married, when you both probably still really like each other. During the marriage, you still like each other, but there are days. Or at the end of the marriage, when your spouse's fondest wish is probably for you to drop off the face of the earth. Obvious point. It is less expensive and emotionally taxing, not to mention more likely to lead to an acceptable agreement, to negotiate it at either points 1 or 2 rather than taking your chances at point 3, which is, I will say, that's what most people do. Next obvious point, waiting to discuss your options in a divorce when that divorce is inevitable is about as sensible as discussing your estate plan on your deathbed. Which they also do. And I will tell you this, there is nothing harder for an attorney who practices in this area than to have a consult with someone. They sit, they tell you their story, and you start talking about, well, basically the default rules are in Virginia regarding assets and distribution of assets and spousal support and so forth in the divorce case without an agreement. And the shock that comes over their face about what is truly in play and what the rules are. The agreement allows you to vary those rules somewhat. You're in luck. I've been the guinea pig. I've been through the divorce process twice now. First without a prenup and second with one. The first time was not fun because not only am I dealing with the emotional fallout that inevitably comes, but I'm also having to consider what could happen and what would my post-divorce life be, whether it would be a giant step backwards. My story, unlike most, had a happy ending in that regard. The second time, I still coped in my own way, but I wasn't worried about any financial or legal affairs. Okay, so we've talked a lot about dissolution, and let's talk about another fun subject, death. And this is the other part. Remember what we said was, marriage ends in one of 2 ways, death or divorce. This is the second part. Estate planning documents, broadly speaking, deal with essentially 2 scenarios. You're dead or you wish you were. Wills are especially important in blended families and in non-marital committed relationships. Why? Virginia intestacy rules which is a fancy word for you died without a will, favor spouses and blood relatives with special rules for adopted children. Pay attention. Absent a will, non-spouses, non-relatives, stepchildren have no claim on an estate. Unless you've made provisions for survivorship rights as to specific assets, or you've named someone as a beneficiary of an insurance policy, or have made some contractual arrangement, non-relatives and your non-spouse, non-relatives and stepchildren will get nothing on your death. If this is not your preferred outcome, you need a will. Trust planning can also assist, but really that's a topic for another day, and probably another lawyer from my firm would be better qualified to speak to trusts and when trusts would be advisable or not. If you're not dead, but you can't take care of your financial affairs or communicate decisions about your medical treatment, well, what then? Well, you need a power of attorney and you need an advance medical directive. And you can appoint anyone as your agent for these purposes. Being someone's, another important point, being someone's friend or spouse or domestic partner by itself doesn't give them the power to direct your business and medical affairs. Quick word for non-marital relationships. Maybe you're thinking that all these problems I've been discussing are solved by just don't get married. You would be wrong. Estate planning is essential if you are not married. The intestacy rules do not favor your relationship at all. Virginia does not presently allow for cohabitation agreements. Some states do. California is an example. However, if you're not married and you're thinking about acquiring assets together, entering into jointly binding legal obligations, for example, if you're going to lease your house together, both be on the lease, if you're going to incur debt together, and so forth, you can negotiate agreements about what happens if that relationship dissolves. How? Well, this is basic contract law. Adults can contract for any legal purpose as long as there is consideration. What's consideration? It can be the payment of money. It can be incurring debt on behalf of another. You can guarantee another's debt, or you're otherwise materially altering your legal position in some way. You have a valuable right, you're waiving it, you're not whatever. However, past conduct is not consideration for a contract. You can't say after you've already given someone money, oh, I gave you that money, I really meant for that to be a no. Doesn't work. Therefore, you need to discuss agreements before you obligate yourself to make big purchases or take on obligations you're not required to legally undertake. I think that's it. Questions? And I think there was one more. I think I may have skipped one.
It's shorter than a legal consultation.
There you go.
Yeah, here we go. Conclusions. Let's go back there for a second. Committed adult relationships require legal planning for both the ways relationships can end, either death or dissolution. Planning for both scenarios in a holistic way brings about a level of legal and financial certainty for both partners. Certainty allows for healthier coping with the grief that results from the trauma of losing your partner in either scenario. And the earlier you address these issues, the better off you both will be. Now questions. Anyone? Yeah.
Yes, so if you have beneficiaries designated that are, not exactly lining up with what your will states, beneficiaries in your life insurance,
That's okay.
Those will take over.
That's correct. That's what we call passing by contract rather than passing by will.
Okay.
And in certain circumstances, doing that can be advantageous in terms of an overall estate plan because it can reduce your potential probate taxes, things like that.
Okay, thank you.
So, but the point is, if you don't have those, not every asset you have can pass by contract or by agreement such as insurance policy. Those assets either are going to pass by will or they're going to pass by the default intestacy rules of the Commonwealth.
So, I have a client who's they're remarried, and one of them has children from a prior marriage. And they own property, they own property that they bought together.
Who's the children from the stepchildren, we'll call them, and the bio parent
Yes.
own property together? Okay.
No.
Bio-parent.
The parents, the step-parent and the parent own the property,
Property together.
bought property
Bought
together, but
property.
only titled it in the name of the person who has the parents of the step.
Okay, the bio parent. Okay, in
Yeah.
this scenario. All right.
And so if he dies,
Mm-hmm.
and what are her rights to property that was in his name when he had children from a prior marriage?
Well, the intestacy rules, because if you're going to the intestate, and let's assume there is no will, if there is no will, it's a 2/3, 1/3 split. The children collectively share 2/3 tenancy and common interest in that, and let's say it's real estate, just because it's easier for me. 2/3 interest, the spouse has 1/3 undivided share. What that usually equals is, if people can't get along, they end up coming to me or Nancy to do a partition suit because they can't, unless one of the others buy each other out. If that is not the intent of the husband, it sounds like in that scenario, then they're going to need some estate planning. Also, keep in mind that, let's say it doesn't end in death, it ends in divorce. Well, even though one party is not on the title, may very well still be considered under the default rules marital property. If that is not the intent of the parties, they need an agreement that says so. In this case, it'd be a marital agreement that says, okay, I agree this is your separate property, if that's what they intend. But,
So let me go a little bit deeper in the weeds.
yeah.
What if she can document that she made all payments on the property and it's now paid off?
George, I will say this, I've had this in a divorce case, the deed controls, because the deed is the overtaking contract. So if you're married and you specifically deed it differently, the deed is the contract, that is the document that controls every time in a divorce, regardless, the deed will control.
But the state law says that the deed may not necessarily be the definitive answer. The point is, you're going to spend money on litigation. Nancy may very well be correct, but you have spent money on lawyers to argue over the point, which if you had an agreement, that would not only bring cost savings to the parties, but also it brings certainty. And that's the point I want to get across to folks is, yeah, we can litigate if we have to, and look, be happy to take your money, and we'll be happy to represent you zealously, but divorce litigation can be very expensive. If you have an agreement in place, that narrows the issues for litigation. I mean, as I said before, if there are minor children of the marriage and the marriage dissolves for whatever reason, you're still going to have to negotiate that stuff, and some things you can deal with, some things you can't. But that's still better than starting and saying everything's on the table. Basically, it becomes a bar fight, and you add to that emotional component about who the parties feel like were responsible for the marriage dissolving, and suddenly things which in better times would not be considered litigable issues now become fights. So, and a lot of, and as I said, you can do that, but, and look, people choose not to have prenups all the time. It's just realize the risk that you take in not having some sort of agreement. Yes?
Robert, you mentioned trusts are not your specialty, but
Right.
what's your opinion of living trusts for
What you're talking about is a revocable lifetime trust. Again, it's going to depend on your facts and circumstances. I think the two things that to me at least, and this is very general, there are two primary drivers of people who use trusts as part of their estate plan and relationship planning. One driver is the value of your asset, of the marital estate, and the potential for state or especially federal estate tax. It keeps, and again, federal state tax keeps bouncing around. Right now, I think if the total marital estate is 8 or 10 million, I can't, Joe or Steve would know this quicker than I would, but
It's about 5.5 million each, so.
yeah, so about 10 or 11 million dollars. Assuming that there's been no credits against it for gifts, and again, that's a whole different story. Basically, tax considerations is one driver. The second driver is blended families. And sometimes blended families are families where you love your children, but maybe they're not the best with money. Those are the kinds of things, or other relatives, not just children. So those are the kinds of things which generally drive that discussion. But as far as what works best for a family is really, you're going to have to talk, sit down, have a conversation with an attorney, and, be prepared to talk frankly and freely about your assets and your concerns. And it's really something that has to be customized.